this case study analysis. This is case study 8.5 in our book, Case Studies in Sport Law, 2nd edition. Found this case fascinating as we discuss our gender equality or equity section of our curriculum. This case is Jackson versus the Birmingham Board of Education. Facts of the case: this was brought about in 2005 from Roderick Jackson, who is a teacher for the Birmingham, Alabama public school system. He was a girls basketball coach. He alleged sex discrimination in Title IX statute problems within the school system that he taught and coached in. This happened in December of 2000, where Jackson began complaining about this discrimination. So, very interesting case. I think it hits home because of the teacher-coach aspect, one that I found highly fascinating just for that aspect, and then how it was handled subsequently by the district courts, the Court of Appeals, trying to understand their reasoning and why they thought the way they did. So, Jackson's argument in December 2000, as I stated earlier, he began complaining to his supervisors about the unequal treatment of the girls' basketball program, but it did not go anywhere. His complaints went unanswered. The school failed to remedy. So, and here's an interesting part of this, Jackson began to receive poor work evaluations and then was removed as the girls' coach in May of 2001. So a little over a year, or actually a little less than a year, about 4 months from when he began complaining, he was removed. He was still employed as a teacher, but no longer was a coach. Now, Jackson had been a Birmingham School District employee for over 10 years. In 1993, he was hired to serve as a PE teacher and girls basketball coach, and then was transferred to a different school 6 years later in 1999. And that was when he discovered that the girls' team was not receiving equal funding and equal access to athletic equipment and facilities, which ultimately led him to what he felt like do a poor job coaching. So that's where the funding discrimination comes into play. After the board then terminated Jackson's coaching duties, he ultimately filed a lawsuit in the Northern District of Alabama. Among many things, he alleged that the board violated Title IX by retaliating against him for protesting the discrimination against the girls' basketball team. Now, obviously, the Board of Education moved to dismiss on grounds that the Title IX's private cause of action does not include claims of retaliation. And guess what? The district court granted the motion. So, the Board of Education, this is a fairly simple one to navigate through. They allege no retaliation had been committed, there was no funding discrimination, and that Title IX had essentially, overall, the overarching aspect of this, not been violated because of that statute that says Title IX's private cause of action does not include claims of retaliation. So, this is where the book really gets fun and interesting, because what we find throughout the reading is that the Title IX clause, when it was enacted by Congress, is really vague. And so it leaves a lot up to the courts and really the plaintiffs to try and come up with proper arguments to show that something wrong had been done. So what happened was the district court granted a motion to dismiss. The 11th Circuit Court affirmed this decision. And basically what they said, and this is important to realize through this, is that Jackson's suit did not provide a claim. meaning he had no evidence. Furthermore, Jackson is not within the class of people protected by Title IX statute as a teacher. Again, very fascinating ways to look at it. So the book really digresses through all this. Let's see here through the book. This was found on page 284. We are convinced by the board's argument that even if Title IX's private right of action encompasses discrimination, Jackson is not entitled to invoke it because he is an indirect victim of sex discrimination. The statute is broadly worded. It does not require that the victim of the retaliation must also be the victim of the discrimination. That is the subject of the original complaint. Okay? So keep that in mind. When the retaliation occurs because the complainant speaks out about sex discrimination, the, quote, on the basis of sex, end quote, requirement is satisfied. Title IX's enforcement scheme also depends on individual reporting because individuals and agencies may not bring suit under the statute unless the recipient has received actual notice of the discrimination. If recipients were able to avoid such notice by retaliating against all those who dare complain, the statute's enforcement scheme would be subverted. We should not assume that Congress left such a gap in its scheme. So, again, the vagueness of this particular statute or clause in the Title IX really gives a lot of leeway to the courts, and you have to lay out a good argument. Obviously, he did not, and ultimately failed in the courts. We have here, the book also kind of gives a little bit of information about reporting discrimination. It says, reporting incidents of discrimination is integral to Title IX enforcement and would be discouraged if retaliation against those who reported went unpublished. Indeed, if retaliation was not prohibited, Title IX's enforcement scheme would unravel. Recall that Congress intended Title IX's private right of action to encompass claims of a recipient's deliberate indifference to sexual harassment. Accordingly, if a principal sexually harasses a student and a teacher complains to the school board but the school board is indifferent, the board would likely be liable for a Title IX violation. But if Title IX's private right of action does not encompass retaliation claims, the teacher would have no recourse if he were subsequently fired for speaking out. Without protection from retaliation, individuals who witness discrimination would likely not report it. Indifference claims would be short-circuited and the underlying discrimination would go unremedied. Again, I just found it highly fascinating because this is something that we're going to see or could see as athletic directors. And so I think the important piece of this is a few things. Number one, as an AD, you need to ensure that there's quality as much as possible across all athletic programs to just avoid any of this. If there is a complaint lodged, you need to take it seriously, investigate, and then act if it's appropriate. I think taking the complaints seriously obviously is going to show empathy towards your coaches. Maybe it's something that you're not even realizing is going on. And so, understanding their point of view and taking into consideration what they're telling you is vital in these sorts of situations to really avoid. And we're talking about avoiding this whole Title IX cloud, because that sends a poor message to the athletes, the parents, and certainly outsiders about your school system. And then ultimately, we've talked about this a ton throughout the course and other courses, is communicate with your coaches. If you're in communication with your coaches, you're going to know if something is off. You're going to know if something is being perceived as wrong. You're going to know if somebody's upset. And then you can act accordingly. You can talk to them about it and then try to rectify the situation. Obviously, what I gleaned from this is that there was a lack of communication, which is why he was complaining. Now, we're kind of vague on who Jackson was complaining to and so on, but he was complaining and getting nowhere, meaning There wasn't strong conversations about it. And by I mean strong, I mean, sitting down and having real, honest um, conversations about where programs are going, what can be done to help out, that sort of thing. These sorts of things should, in theory, come up during evaluations. He was hired in 1999. In 2000, or he started complaining rather in 1999. He was hired in 1999 to coach the girls' team at Inslee, which is his second school. In 2000, he began complaining about the unequal treatment. But he realized in 1999 when he was hired the funding discrimination. So it's important to have these conversations as an AD, and you can't hide from them. You got to hit these things head on, and you want to, again, avoid that cloud of Title IX over your school.